All right. Hi, everybody. Welcome to Logically Speaking with Shiobhan Olivero. I am your host, Shiobhan Olivero, and I am an attorney in Florida. So, welcome to my first premiere episode of Logically Speaking here live on Facebook Live. And I will also be downloading these and they will be going up on our YouTube page as well. This is going to be talking about all things legal. It's going to give you Florida legal tips. It's going to give you some business, running a law firm, business law tips, um, law firm running tips. And we're going to talk about anything and everything legal here on this show. So tonight, I wanted to talk with you about sealing and expunging records. Every day, my firm Olivero Law Facebook page posts a legal tip of the day. And so sometimes that's what I'll be coming on live to talk about as well, is that legal tip of the day that we posted on our law firm page. So go to our law firm page, Olivero Law PA, and like and follow us there to get daily legal tips of the day. And so today I'm going to talk to you about that. And in Florida, we are going to talk about sealing and expunging records, what you can and can't have sealed or expunged, what the difference on sealing and expunging a record is, and what that means for everywhere that your criminal record might be posted. So let's talk about the difference of what all of that is. I am often asked how to seal or expunge your criminal records in Florida. And so, first, let's talk about what the difference between sealing and expunging a record is. So, expunging a record is where, by court order, the record has to be physically destroyed by any criminal justice agency that has custody of the record. So that means it's going to physically be destroyed by the clerk of court, the arresting police agency, the state attorney's office, and any other criminal justice agency that has access to that record. They actually have to physically destroy their files. That includes digital information and their computer records and their physical records. However, any identifying information such as DNA or fingerprints are not destroyed. The only agency that's going to maintain a record of the arrest per the statute is going to be FDLE, or the Florida Department of Law Enforcement. So that's expunging. So what is sealing a record? So sealing a record is when the record is ordered to be sealed. They don't have to destroy them, they just have to seal them. So they're going to go in a confidential sealed envelope, and they are not going to be going public and publicized to anyone. So it's kept on file still with the clerk's office, the state attorney's office, and the arresting agency. And it's, as I said, it's placed in a sealed envelope and it can't be viewed by the public unless a court order to unseal that envelope is obtained. The Florida Department of Law Enforcement, or FDLE, also keeps a record of that arrest and criminal charge. So, what do you have to do to qualify to have your record expunged? And then, what do you have to do to qualify to have it sealed? There are different qualifications for either one that you're trying to do. So to have your record expunged, which is where it is completely destroyed, you must never have been adjudicated guilty, or what we call convicted of a crime or an ordinance. You must have never secured a prior sealing or an expunction of a criminal history record. There's one exception to that, and that's if you have had your case sealed for 10 years, then it might qualify for expunction. You must have been arrested for the criminal charge. And if the case has to be either closed by no charges ever being filed, or by a dismissal, or by an acquittal by a judge or a jury. And so that is what it takes to have your record expunged or destroyed by those agencies. To have your record sealed, the following qualifications have to be met. You must never have been convicted of a crime or ordinance. You must have been arrested for a criminal charge. Importantly, you must have received a withhold of adjudication. So that's the withhold of the conviction by the judge. And you must no longer be under any type of court supervision or sentence to be able to apply to have your record sealed. So, some important notes about having your record sealed or expunged, and it is a one-time lifetime benefit. So, you can only have one record sealed or expunged in your lifetime. So, that means if you have two prior criminal charges that arose from different arrests and both could be eligible for sealing or expunging, you have to choose the one of the two records to have sealed or expunged. But if you do have numerous criminal cases and they directly relate to the same original arrest, then the court can, at its discretion, order the sealing or expunction of that entire arrest record if multiple cases came out of one arrest record. Importantly to note is that there are certain crimes that can never be sealed or expunged, regardless of whether you had a conviction or a withhold of the conviction. Some of those crimes include crimes like arson, some assault and battery charges, including domestic battery charges, elderly abuse, child abuse, kidnapping, murder, sexual offenses, stalking offenses, robbery, carjacking, acts of terrorism, certain drug charges, and computer pornography, and also some of the traffic offenses like a DUI charge can never be sealed or expunged, predominantly because that requires a conviction under the statute. Note that those are not all of the charges that are exempted or can never be sealed or expunged. So you do need to contact an attorney to you review your case to see if your charge qualifies. And we also have to check records to ensure that one, you've never been convicted, so it requires pulling a criminal history in your background and was to make sure there's never been a conviction. And we also have to make sure that that particular charge under qualifies under the statute, but that you received the right withhold of adjudication for it to qualify. So I'm not going to talk about the entire process to seal or expunge your record in this show tonight, but essentially, to have your record sealed or expunged, there is quite a lengthy process. There's you have to apply with the Florida Department of Law Enforcement, who has to then check your entire history, obtain a certificate of eligibility of that, and then you submit. There's fingerprints and certified dispositions of your record. All of these things have to go to FDLE. They give a certificate of eligibility if you qualify, and then the appropriate documents and forms have to be filed with the court, and a motion filed, and a hearing held, and then finally the order done by the judge. Um, it takes a very long time. It's a very lengthy process. What I tell clients who come to me that we're doing sealing or expunging of a record for is that just that FTLE portion, from the time you get me the completed application, as I walk you through and I help you through it and tell you everything you need to do on that application. But once you get all of it back to me and then we get everything together and send that off to FTLE, once FTLE receives it, it's typically at this point in time somewhere between a 6 to a 9 month turnaround time from for FDLE just to get us that certificate of eligibility. Sometimes shorter, sometimes longer than that. That's just an average. It does take them a very long time, and it's a very lengthy process that you have to be patient for. And so there, if you have applied and it was denied, there are reasons for FDLE to deny that, and you can have an attorney look at that. We'll be happy to look at that and review that for you to see why it was denied and see if there's something that we can do in that process. If FDLE, for instance, maybe got your background check wrong or they found something that isn't accurate, we might be able to help with that or tell you why it was denied based on whatever that it was that they found. So, who has access to your record once you do have it sealed or expunged? Because there are exceptions when you have your record sealed or expunged. So, people who still can, or agencies that can still see your record, are certain criminal justice agencies, certain agencies for criminal prosecutions, the Department of Children and Families, and other agencies associated with that, the Department of Education, or other school boards, universities, other boards and childcare licensing facilities, and for firearms purchases that are subject to a background check. So those are some of the agencies that may still get access to your record, even though it has been sealed or expunged, and that's per exceptions into the statute. So the next question that I usually get on this topic is, can once your records have been sealed or expunged, are you able to lawfully deny the record? So for instance, a lot of times on like an employment application, you get asked, have you ever been convicted of a crime? Or have you ever been arrested of a crime? And so so some of that really just depends on whether you have to acknowledge that criminal record or not. So, and whether if you have a question on that, if you're applying somewhere and you've had your record sealed or expunged, please contact an attorney. We'll be happy to tell you about that. There's a lot of exceptions on that. So, I'm not going to spend a whole lot of time on that other than tell you that's on a case by case basis. And depending on who you're applying with, and if it's one of those agencies that um, have an exception under the statute, you may need to disclose that. So, with all of that said, that gives you a brief overview of sealing or expunging a record. And so, the final point that I want to talk about on sealing or expunging a record is once we get that back from FDLE and you qualify, and then we also go further and we have that order from the court that allows your record to be sealed or expunged. I want to go back and touch on the agencies that I said that that applies to, which is the clerk of the court, the state attorney's office or the prosecuting agency, the arresting agency, and of course, FDLE keeps a copy of it, but it only goes to those agencies. So many people out there are familiar with like the third party websites like mugshots.com and there's a ton more, but some of those third party, they're private websites, and having your record sealed or expunged does not apply to them. So if you have been arrested and one of those sites has your arrest record up or your mugshot up, you have to contact each and every single one of those third party sites individually and request that they take it down. You should have the order sealing or expunging that you can provide to them, and that should help you to have to help ask them to remove it. But it doesn't apply to them, and they aren't bound by that order to have it removed. Although there are some some things that they do have to comply with outside of that may require them to take it down. But just wanted to note that it doesn't apply to those private third party type of sites
Mhm.
that monitor and post different types of arrest records. So that is an overview, a quick overview and short insight into how to have your record sealed or expunged and the top questions that I get on that. Please feel free to contact us. You can find me on Facebook and send me a direct message or under Olivero Law, or my information is there. You can email me at info@oliverolaw.com and set up a time if you have any further questions, and we'll be happy to talk with you. And again, just to note that this is only in Florida, and this is as to Florida law sealing or expunging. And we're happy to review anything that you might have a question on. So until next time, we will talk to you soon.